Face the child in the present the conference the accused, Aileen Wuornos, and her attorneys Billy Nellis and Tricia Jenkins. The state was represented in this matter by David DeWolf, state attorney. Counsel, you've had an opportunity to see the proposed verdict forms, not verdict forms, but the proposed instructions to be given that are taken from the standard book. And we will start down to the point where it says the aggravating circumstance should be given. Is it the request of the parties that we omit those items that are not aggravating factors? And I'll get back into it in just a moment. You do?
Yes, sir. We would make that request. Now, we also have specific issues as to the aggravators themselves when we get to them, but that would be, I think, the general request. Mr. DeMore, you as well.
All right, now you have seen these, and we'll go through them paragraph by paragraph and state your objection.
Yes, Your Honor. As to paragraph 1, sentence 1, there's the language in there that indicates her crime. We would request the language the crime. We think her crime suggests to the jury that the court may have an impression would be improper under the Eighth Amendment.
Let's say the statement.
On the standard instruction, Judge, the gender is there. We have the standard form.
Secondly, Your Honor, there are a number of Caldwell versus Mississippi-based objections. Caldwell, C-A-L-D-W-E-L-L versus Mississippi-based objections. The first as to that would be in paragraph 1, as you have been told, the final decision as to what punishment shall be imposed is the responsibility of the judge. And then there's further language in that same paragraph relating to an advisory sentence. We would request that Your Honor not give language that suggests to the jury in any way that diminishes their sense of responsibility pursuant to Caldwell versus Mississippi and the Eighth Amendment. And we would also request that if Your Honor will be giving the language and the instructions in their current form, that Your Honor add at the end the language, your recommendation is important and will be given great weight in imposing sentence. We feel that although that does not ameliorate the effect of the Caldwell problems with the prior language, that at least indicates to the jury that there is some importance to their verdict.
All right, then. Even though it is outside of the standards, I will give it because I put it in my proposed instructions for you to review. Your other objection.
A wealth of Florida Supreme Court case law going back to Dixon, Provence, tons of other cases I won't rattle them off, indicating that you should not double aggravating factors in this manner. And it is just as improper to double them before the jury as it is if the court were to do it independently. And we would request that the state either select one of these aggravators or that Your Honor not instruct them both. And as it currently stands, we would object to the giving of this instruction on 8th and 14th Amendment grounds. Moreover, as to the pecuniary gain aggravator, an instruction is necessary to define for the jury what the heightened mental state level is making that aggravator applicable. And the current instructions do not have that, and we object to that again on 8th and 14th Amendment grounds.
Judge, I think by counsel's argument, he's conceding that the Supreme Court of Florida has already determined that it's proper to give the jury both charges in situations such as before the court. I take it that he's arguing that case law would be improper for the court to double that should you find it perfectly has been upheld that the jury should be charged on both offenses and both aggravators. We'd have to be done.
Right, they be granted and the objection is noted in the record and overruled. There is one thing I would like to concede this. The standard charge calls for financial gain. The statute says pecuniary gain, which is the choice of the defense.
The defense would prefer, it doesn't matter much, we would prefer pecuniary.
Pecuniary. All right, the next one.
The next one's really bad.
The next one is a crime for which the defendant's sentence was committed to disrupt or hinder lawful exercise of government. Is that requested by the state?
Yes, sir. I'm sorry. No, I'm sorry. No. I was going to ask that.
Correct. The next one requested is the crime for which the defendant is sentenced was especially wicked, evil, atrocious, or cruel. And you have seen the proposed charge that defines those words.
Yes, Your Honor, we would respectfully object to the proposed grounds on the basis of Maynard versus Cartwright, Godfrey versus Georgia, and a wealth of other Eighth Amendment case law. This instruction is vague, ambiguous, is not sufficiently narrow, and channel the jury's sentencing decision and violates the 8th and 14th Amendments.
Your Honor, the evidence in this case supports the giving of the instruction we requested.
The next one is the crime was committed in a cold, calculated, premeditated manner. Is that requested?
Yes, sir.
Your Honor, as it currently stands, the instruction fails to provide a sufficient, it does not have a sufficient definitional component comporting with Maynard versus Cartwright and Godfrey versus Georgia. We have submitted to Your Honor proposed instructions as to the cold, calculated, premeditated aggravator. As to the premeditated aspect of it, we've submitted a proposed instruction which seeks, and orally have requested an instruction, which seeks to meet the Florida Supreme Court's discussion in Rogers versus State as to what heightened premeditation is and how the jury should go about considering that issue when dealing with this aggravator. As it stands right now, any jury convicting in a first-degree murder case would apply this aggravator as currently phrased here because there's no definition as to what heightened premeditation means, which the jury can consider. As to the cold, calculated aspects of it, those two suffer from vagueness, Your Honor. In a certain sense, any felony whatsoever can be considered cold and calculated. As to the aspect of lacking a pretense of moral or legal justification, again, definitional language would be necessary as to that as well as to the other aspects of that aggravator in order to meet what the United States Supreme Court spoke to in Godfrey and in Maynard. The Florida Supreme Court has spoken to this issue as well on a number of occasions, including Rogers, and we would object to the giving of this instruction in its current form on 8th and 14th Amendment grounds, and note to the record that we have submitted certain proposed instructions on it.
Yes, sir. I'll rule on those in a few moments. The next aggravating charge is the victim of the crime was a law enforcement officer, and the following was an elected public official, and I assume the state are not requesting those.
Right, Your Honor.
All right, we will move into the next section of the standard charges that if you'll follow in your book about if you find that the aggravating circumstance did not justify the death penalty, your advised sentence should be one of life in prison without elderly parole for 25 years. Now we go into the mitigating circumstances.
Judge, on that one, other than the word advisory, which involves a Caldwell issue that I spoke to earlier, we have no objection to its current form.
All right, and then the aggravating circumstance do not exist. Now, you have submitted some proposed charges, and I'll rule on them later.
Yes, Judge.
In regard to this paragraph.
But as to the burden shifting aspect of those paragraphs, again, it speaks to whether mitigating circumstances exist that outweigh aggravating circumstances. And Your Honor heard the previous argument on the burden shifting and the 8th and 14th Amendment issues. I won't restate it all, but note the objection.
All right. Does the defendant request the charge on significant history?
No, Your Honor, we waive that charge at this juncture.
The next is the crime was committed while the defendant was under the influence of extreme mental or emotional disturbance.
We would request that the court give that charge, Your Honor.
Granted. The next is the victim was a participant in the defendant's conduct or consented to the act.
We would request that the court give that instruction, Your Honor.
State the objection, Your Honor.
The request is granted, the objection is overruled. The next one is about an accomplice.
We would not request number 4.
Will not be given. Number 5, extreme duress or substantial domination of another person.
We would request that one, Your Honor.
State the objection.
I think that will be a doubling again, and I don't know of any person that was dominating her here that I've heard any testimony to.
Judge, we didn't discuss this off the record, but if you want, I can tell you.
Right, I think I would like to hear it on the record.
On the record, Your Honor. First, the the language of the statute is in the disjunctive. It doesn't say the extreme duress has to come from the substantial domination. It says extreme duress or substantial domination.
I have that.
And given the disjunctive language in the instruction, the mental health evidence that Your Honor heard would relate to a psychological form of duress. Secondly, Judge, the substantial domination also relates to evidence that you heard about the interaction, interplay, and influence between Ms. Wuornos and Ms. Moore. And so we would feel that although it is phrased in the disjunctive, there's evidence to support both of those in this case. And therefore, that instruction should be given as to that indicator.
That request is denied as to paragraph 5 of the standards.
Please, another objection.
Yes, sir.
On anything.
Your request is denied.
Right, and I'm saying, please, yeah.
The next one is the capacity of the defendant to appreciate the criminality of conduct.
We would request.
And I'm going to strike the word is and just put in her aspect that you want to look at. I would suggest we leave the word other in. If you want it stricken, I will deny it.
Ms. Jenkins suggests that we leave it in, Your Honor. I will defer to her.
The majority rule, 1-to-1 lady wins.
This one's Tricia.
1-to-1 lady wins. All right. Now we go to the next paragraph of the standards. The aggravating circumstances. From here on out, the standards are in effect as far as my proposed orders are concerned.
Yes, Judge, and we don't have anything specific until you get down to the bottom. You will now retire.
We'll finish it.
Yeah, and then we'll go. If I may, Judge, just to go through the standards and then we'll go back to some specific things.
Yes, sir.
On the standard language, the only concern we have is both in the last paragraph and in a couple of references prior to that where the sentence is spoken of.
Deny, but if you want some demonstrative list to go to the jury, you can use the board.
Okay. Yes, Your Honor, we would request an instruction.
Well, I don't have anything in writing, so I don't know what you want.
On the verdict forms.
Yes, sir. Now on the verdict forms, I believe that you've had an opportunity to see them. They track the wording of the statute and of the rule. The verdict form proposed just leaves off the word without possibility of parole for 25 years, and that will be added before it's delivered to the jury.
No objections or substantive requests. I don't know if you want to change foreman to foreperson.
Yes, I generally do that. Our original verdict says foreperson.
And Judge, for the record, we would object to the without possibility of parole for 25 years language. We think that.
You want it deleted
Yeah.
in the verdict form?
Yeah, because it tracks the statutory one.
I will omit it if you know it. It's in the chart and it's in their recommendation. It's in the standard chart.
We have the standard charge.
I think it was in this.
Okay.
Just here.
Yes, I'm.
Thank you.
Right.
All right, so I will leave the without possibility of parole for 25 years in the standard. Does the state have any requests for additional instruction?
There's Dude, I think I've already voiced my objection before giving victim participation.
Yes, you. All right. Ms. Wuornos, have you been able to track with us what we're doing here?
Not really.
No. Do you have any
I have
objections to
bad
the thing?
hearing, so
Ma'am?
I have bad hearings,
All right.
but
Well, you've had an opportunity to observe us at work, and so we will call it a night, council.
Thank you, Judge.
9:30 tomorrow. Now, I think it's going to be up to us about the order of argument. I don't know how you want to do on this. Opening, closing, or opening, closing, middle shot, or what?
My understanding is state goes first, then defense goes, that's all you have.
I'm asking how you want to do it.
It's fine with me.
State go first, defense go last?
I think it's discretion in the court.
It is, and that's the reason I'm asking for guidance. I don't want to impose my will on anyone.
We're asking for opening and close.
Where the state presented, go ahead, sir. I thought you were consistent.
Well, no, I wasn't going to say anything.
It's typically done, Your Honor, and the state goes first, and defense goes last when both sides present evidence.
Nothing for rebuttal.
And you have a case here where both sides presented
That's right.
evidence, so.
That's right. That means they have a right to rebuttal.
Well, no, not in the penalty
Not
phase.
the penalty phase, Your Honor.
There's no, let me just tell you, there's no statutory requirement that rebuttal be allowed.
I know it.
In general, in these proceedings, where both sides present evidence, you go, one side argues, the other side argues, and it makes sense that the defense gets to argue last, given what you're dealing with in a penalty phase. And that's why the statute does not have a rebuttal requirement, unlike a trial where there are
Right.
different interests.
I'll grant that request. State go first, defense go last.
Thank you, Your Honor.
Court one's by the jury.
Right.
Yeah, time. All right.
We're done, Judge. Good night.
Yes, sir. We'll see you at 9:30 a.m. tomorrow.